Hey guys, welcome to today's video, and today is your last set of notes for AP Government ever. So hopefully this Unit 9 hasn't been so bad through remote learning. So far up until this point, we've talked about civil liberties and how the 14th Amendment's Due Process Clause both protects that or incorporates that via the Due Process Clause and also balances the independent freedoms that we have and the social order that we all need. But today we're going to be focusing on the civil rights piece of our unit and the social movements that have spawned from it. So you guys have talked about the civil rights since probably fourth grade. So this is going to be a very broad overview of what the civil rights movement is, and specifically how the 14th Amendment protects that. So by the end of these notes, you have three goals. The first is to explain how that Equal Protection Clause of the 14th Amendment has supported and motivated social movements. Identify and explain how the government responds to social movements through court rulings and acts of Congress, and identify examples and instances in history where minority rights have been restricted and examples of where they have been protected over time. So let's start with basics in terms of civil rights. Civil rights are policies designed to protect people against arbitrary and discriminatory treatment by the government or individuals on the basis of race, national origin, religion, sex, age, disability, etc. So that is a very long list, right? Essentially what that means is everyone has to be treated according to, by law, equal to one another, right? You cannot be treated differently because you are a part of a specific group. And when we are talking about civil rights, think of it like this, right? The right to ... So for example, we're going to see in the various social movements that we look at today, the right to marry, the right to work, the right to vote, for example. And these civil rights are really going to be pushed by the Equal Protection Clause of the 14th Amendment. And we've looked at the 14th Amendment as this defining amendment, not only for civil liberties, right, the Due Process Clause, incorporation of the Bill of Rights to the states, but now this Equal Protection Clause. And something to note is that this Equal Protection Clause has really been the main motivator for movements for equality, in part because it doesn't specifically mention one group of people. It doesn't mention exactly who is being referenced. So it's not just African Americans. Other minority groups like women, the LGBTQ community, other ethnicities have benefited from the Equal Protection Clause in their search for equality. Now, something to note, and this is where your learning target comes in. As the Supreme Court has really interpreted this Equal Protection Clause regarding equality, sometimes it has protected civil rights of African Americans and other minority groups, and sometimes it has restricted those civil rights. And we're going to be looking at examples of how this has happened through various groups and social movements today. Now, the reason that this happens in large part is usually due to the makeup of the court, right? We've talked about how the court's supposed to be this independent body, free of political pressures, but we know that the Supreme Court isn't in a vacuum, right? Justices come in with their own ideologies, their own positions on whether they should be activists or follow more judicial restraint. So some justices are more conservative, some are more liberal, some are going to be more apt to follow, public opinion and political pressures. Now, something to consider when we're talking about civil rights is exactly what is equality, and that can be distinguished differently. And this is a question that the courts have grappled with, right? There's this difference between equal opportunity and equal results. Equal opportunity meaning that everyone gets the same opportunities. But as you guys know, not everyone has this, right? There's a difference between being born in a very high socioeconomic status versus someone who was born not in a very high socioeconomic status, right? There are differences in the opportunities that they have because of their position when they are born. So this is really what we focus on when we're talking about civil rights policies, right? How can we prevent this from happening? How do we remove the barriers that prevent this equal opportunity from happening? One of the biggest examples right now that's being talked about is free college, right? If we remove that barrier for some, that college costs too much, we can create equal opportunity for success, right? Because getting a college degree is often seen as a good measure for being successful in life. So how can we navigate that barrier? Now, equal results, on the other hand, think of it like a race, whereas equal opportunity, everyone starts out the same. Equal results would be the fact that everyone would finish the race at the same place. Ending with everyone having equal things. We in America tend to lean more toward equal opportunity versus equal results, because equal results tends to lean more toward that communism, socialism side of things. And as we've talked about, those tend to have more negative connotations in our society. Now, we're going to talk about civil rights over time for a couple of different groups, and we're going to start with race simply because African Americans have been fighting the longest and the hardest due to the fact of slavery. So, right, during slavery, we have things like the Dred Scott decision that's going to really push back civil rights, right? The idea that even though a slave would be living in free territory, they were still considered property and therefore could not be did not have rights in the justice system, right? You have to remember the 3/5 compromise that we saw when we created our Constitution. Now, it is really the Civil War and Reconstruction that put civil rights into the forefront of government action. So after the Civil War, we see I should say, Congress passed the Reconstruction Amendments, and the goal of these was to protect freed slaves, and also they were passed as a condition of states to resume delegation in Congress, right? If you want to rejoin Congress and have representation, you need to adopt these amendments. So we see the 13th Amendment outlawing slavery. We see the 14th Amendment that we've talked about already, outlining many important things that will come to establish civil liberties and rights, specifically citizenship, due process, privileges and immunities between states, incorporation of the Bill of Rights to states, and equal protection, which we are talking about with civil rights today. Now, the 15th Amendment prohibits states from denying the right to vote to anyone on account of race, color, or previous condition of servitude. So what this does is effectively give all men the right to vote. So you should notice who's missing from that category. And as you can see or probably predict, and as you know, that's going to lead to social movements in the future. So let's talk about the period of time specifically in the South after the end of the Civil War, during Reconstruction and segregation. Now, there is a term that is very important for us to know, and that is de jure discrimination. And we're going to compare this with de facto discrimination later in these notes. But de jure discrimination basically means that a law is in existence that discriminates against a particular group. It is institutionalized through law and policy. So an example of this would be Jim Crow laws. Jim Crow laws sprung up in the South once federal troops withdrew after the Civil War, right? Ultimately, protections against people of color had been dismantled, and this de jure discrimination set in. So we see Jim Crow laws being put into place by local governments to disenfranchise or remove the right to vote from people of color, to put in discriminatory practices and segregation. And this is where we see the court responding to these social movements, or the Times, I should say, by ruling in Plessy versus Ferguson, that infamous separate but equal doctrine, right? Ultimately saying that as long as facilities are equal, they are constitutionally allowed to be separate. So this is an example of interpretation of the 14th Amendment restricting civil rights for minorities, as it really upheld those segregation laws that had been passed in the South. Now, we also see local governments circumventing or going around the 15th Amendment, specifically when it comes to that right to vote, requiring everyone to own property, which not many freed slaves own property, literacy tests, poll taxes, grandfather clauses, holding white-only primaries, right? The South is going to believe, mostly the South, that disenfranchising the Black voter is going to return them to second-class citizens, and these Jim Crow laws that got them around that 15th Amendment were loopholes that didn't necessarily violate the 15th Amendment, but simply made it very, 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 very hard for them to vote, right? So like your grandfather clauses, for example, right? If your grandfather could register to vote, you didn't have to take the literacy test. Well, the problem was at the time of these grandfather clauses being put into place by local governments, the grandfathers of freed slaves had been slaves, so therefore they could not register to vote. So this is an example of that de jure, by law, discriminatory practices. So once we see, or hit, I should say, the 1950s and 60s, we really see the push for a civil rights movement, right? We've lived through segregation, and now we're going to see a social movement and Congress and the courts responding to it. So in the 1950s, we see the creation of the NAACP, the National Association for the Advancement of Colored People, spurred by the 14th Amendment's Equal Protection Clause. And they're going to slowly chip away at those de jure discriminatory laws, those Jim Crow laws. And they're going to start with the court system to advance civil rights. And one of the biggest institutional or landmark court cases is going to be Brown v. Board of Education, which is going to lead to the desegregation of schools. And this is going to be a very good example of judicial activism, right? Responding to the times, not necessarily looking at original intent, but responding to the needs of society as a whole. So this is effectively going to overturn the ruling of Plessy and effectively say that segregation is both morally wrong and psychologically damaging. So the court ruling itself of Brown v. Board said that, look, separate is not equal. Children of color are not receiving an equal education. And on top of that, it's psychologically damning. And the lawyers for Brown v. Board actually brought in sociologists and conducted a study of the doll test. So in the courtroom, they had little girls who were African American, and they put in front of them two dolls. One was white, one was black. They were identical. And what they did was ask them to identify who the nice doll was, and every single one of them pointed to the white doll versus the doll that looks bad. And every single girl or child pointed to the black doll. So this was, this allowed the NAACP lawyers to argue that segregation caused feelings of inferiority in the black child. And this was ultimately a very, very successful argument. Now, Brown is also an example of a response to social movements, but the response of Southern local and even state governments does show some of the checks that occur on the Supreme Court power, right? For example, the Supreme Court cannot enforce these rulings. It could not enforce segregation happening right away. So we see delays in desegregation, and we also see, in some instances, flat out refusal to desegregate. If you've ever heard of the Little Rock Nine, right, the president had to federalize the National Guard to ensure that those children of color could attend the school. So just as a, as a check on Supreme Court power here. During this time, we're also going to see Martin Luther King write the letter from a Birmingham jail. And this you will actually read tomorrow and analyze. But this is really going to be his response to this idea that people of color should wait for a better time to obtain equal rights. And he's going to put forward his proper way of achieving the results that he wants. Basically, he's going to express disappointment in the people who are pushing against the civil rights movement, as well as laid the foundation for nonviolent resistance against segregation. Now, in 1964, Congress is going to respond to the civil rights movement by passing the Civil Rights Act of 1964. And this is going to do a couple of things. It's going to ban discrimination in public accommodations, public facilities, and in hiring practices. And it's going to strengthen voting right legislation. So open things up a little bit more to people of color over time. We're also going to see the 24th Amendment being passed that's going to outlaw poll taxes or fees that were required to vote, which minorities and people of color could often not pay, so therefore they could not vote. And we're going to see the passage of the Voting Rights Act of 1965. And that is going to help formally or end the formal and informal barriers to voting. So you're going to get rid of those literacy tests. You're going to get rid of the grandfather clauses, as I just said. And then also the Voting Rights Act is going to discuss majority and minority districts, which we've actually talked about with our landmark case of Shaw v. Reno. But before this, with the Voting Rights Act of 1965, voting districts where a minority group made up the majority could be created to basically redress situations where African Americans were not allowed to fully participate in elections. So according to the Voting Rights Act of 1965, the creation of majority minority districts was okay. It was actually expected to kind of accommodate and redress past wrongdoings for people of color. Now, that has since been revised by Shaw v. Reno, right, which we know when we talked about gerrymandering, race cannot be the sole factor when redistricting, and it has to come under strict scrutiny. So Shaw v. Reno is actually an example of upholding the rights of the majority and restricting minorities. So our second group that we're going to take a look at besides African Americans and race in terms of civil rights are women and gender groups. So really, when we look at the fight for women's equality and civil rights for women, the women's movement breaks it down into waves of feminism. So the very first wave of feminism was really fighting for basic rights meaning the right to vote, the right to own property, those basic things that everyone deems necessary to have. So that culminates in the passage of the 19th Amendment, which extended the right to vote to women in 1920. And during the first wave, we also see laws designed to protect women. So for example, the Equal Pay Act of 1963, trying to minimize the wage gap between men and women. And that Civil Rights Act of 1964 that we talked about with people of color actually does protect women as well, because it protects all groups from discrimination in employment. So that actually protected women as well. During this first wave, we also see the National Organization for Women, or NOW, be created in 1966. So just like the NAACP is going to be formed because of this movement created by the 14th Amendment's Equal Protection Clause, we're going to see an organization and many organizations fighting for female equality as well. The second wave of feminism is a little bit different. So now that basic rights have been met, the second wave is going to focus on personal equality. And as we've talked about, Roe v. Wade is going to be very important to that movement for personal equality, right? This idea of right to privacy, that a woman can have an abortion in the first trimester and cannot be prevented by the states. Now, this has also created the pro-life movement, where, the question of, is the fetus upon conception basically covered by that 14th Amendment's right to equal protection? When does that right to equal protection start? Right? We talked about in the last video of due process. Is it at conception? Is it when the fetus is viable, around 22 weeks? So we've seen both of these movements, Roe v. Wade's spawning the pro-choice and the pro-life movement, really being pushed by that 14th Amendment's equal protection as well. The second wave of feminism also has focused on women entering the workforce and breaking the gender gap. So doing jobs that are traditionally done just by men. This was a huge focus on that second wave. And in the 70s, we see the passage of Title IX, which is actually an amendment to the Civil Rights Act of 1964. And this guarantees that women have the same educational opportunities as men in programs that receive federal funding. So this really impacts colleges a lot. And basically, it just says that colleges must basically provide opportunities that are equal for both sexes in proportionate numbers. So oftentimes, Title IX will impact sports programs, for example, in colleges. Our final category that we're going to talk about is the LGBTQ community. Now, before we look at some key court cases, it's important to know how things have changed over time. So in 1996, the Defense of Marriage Act was passed, and this defined marriage at the national level and declared that states didn't have to recognize or accept same-sex marriages that were accepted in other states. Something very significant that had always been fought since that time was that this act barred federal recognition of same-sex marriages for purposes in terms of Social Security, federal income tax filings, employee benefits. So spouses could not receive benefits in case their partner died, for example, which is something that is given to heterosexual couples. So what we see are a couple of key court cases that expand these civil rights to same-sex couples. The very first in 2003 was Lawrence v. Texas, and this basically said that state laws may not ban sexual relations between same-sex partners. So it's going to decriminalize homosexual behavior. And then the most important and the most recent that we will talk about is Obergefell v. Hodges. And this was very significant because it says that states cannot prevent same-sex marriage. And they have to basically, since they have to legally recognize, they have to provide, or the federal government has to provide financial and federal benefits that come with marriage as well. So those Social Security benefits, the income tax filing benefits, the employee benefits that were denied under the Defense of Marriage Act are now incorporated into same-sex couples. Now, something to note, there are a lot of contemporary issues because just like with Brown v. Board, right, just because Obergefell v. Hodges says that states cannot prevent same-sex marriage doesn't mean that the fight for civil rights is over. Right, public schools right after Brown didn't desegregate right away, right? It took over 100 years of law and litigation and public opinion to change to the point where, you know, we look at that and we say, yeah, that was a pretty bad thing. That was a pretty horrible decision to incorporate separate but equal, right? With specifically the LGBTQ community, right? Not all Americans have accepted the ruling of Obergefell. We're seeing a lot of contemporary issues, specifically because that Civil Rights Act of 1964 doesn't include LGBTQ persons when it defines a lot of these protections. So what we're seeing is workplace discrimination, refusal to serve people who are in a same-sex relationship, right? Because that Civil Rights Act doesn't define LGBTQ persons as those who merchants cannot refuse service to. Some states allow for protections if it's based on the merchant's religious views. That's going to be the most common reason given for refusal to serve. And then we also have transgender issues, specifically looking at in schools and in government buildings, restrooms, locker rooms, etc. So we definitely have a long way to go in terms of defining these, just like we had a lot of issues in terms of definition when it came to desegregation and Brown v. Board of Education. So that concludes our journey of civil rights over time for some of the biggest groups that have fought for equality through the 14th Amendment's Equal Protection Clause. So make sure to write down any questions, go